Hi, I'm Richard Nemeth. I'm a bankruptcy attorney in Cleveland, Ohio, and I want to talk today about what personal property items you're able to keep when you file bankruptcy. Clients often want to know what personal property they'll be able to keep when they file bankruptcy, or conversely, what property they'll lose if they file bankruptcy. Some people have this notion that when you file bankruptcy, you have to give up everything that you own. That is not true. Every state has laws which set forth what a person can keep when he or she files bankruptcy. Neither the state nor the federal government want to take all of the assets away from someone who files bankruptcy, because if they do, then that person is at great risk of having to rely on the government for services like welfare, food stamps, etc. And that is a burden on the taxpayers and on the Treasury, and especially in this day and age, no one wants that. So states pass laws that allow debtors to keep certain assets protected from creditors. In other words, these laws set forth what your creditors can never take away from you if you get into trouble financially. So, what can you keep? Well, the exemption statute in Ohio divides assets into categories, and then you can keep a certain dollar amount for each of these categories. For example, with regard to cash and cash-like items, you're currently able to keep $450 per person. If you're filing a bankruptcy as husband and wife, you're able to keep $450 each, or a total of $900. However, Ohio also has something called the wild card exemption, which can be used to protect anything of value, including cash. And so if you use the wild card to protect cash, you can protect $450 with the cash exemption and $1,225 with the wild card exemption, for a total of $1,675 per person. If you're married and filing joint, each of you can keep that amount. With regard to TVs, appliances, stereo equipment, furniture, pots, pans, and other household goods, basically you can keep all of it. It's an extremely rare circumstance where anyone has to give up any household good, because the exemption amount is $12,250, which is almost always substantially more than household goods are worth. So, the general rule is that you can keep all of your personal property when you file bankruptcy. It's rare that you would have to give any such property up. One exception to that rule is tax refunds. The court looks at tax refunds sort of like a savings account. So let's say you file your bankruptcy case on July 1st, which is halfway through the calendar year. And let's say that you get a $6,000 refund the following spring when you file your tax return. The way the court views this is that IRS is holding half of that refund at the time that you file bankruptcy, because you're halfway through the year, and the court assumes that half of the money has been paid in already, or $3,000. So, if you use your cash exemption and your wild card exemption for $1,675, that leaves $1,325 unprotected, which you may have to turn over to the trustee in this example. So, when you get your $6,000 refund the following year, $1,325 of it would have to be turned over to the trustee, but you would be able to keep the rest. Having said that, there are strategies to help you keep those funds too. For a full list of all of the property you're able to keep when you file bankruptcy in Ohio, call or email us and request our pamphlet about the Ohio exemption statute and what it allows debtors to keep when they file bankruptcy.